Imagine filing a complaint at work and then human resources becomes the bully you never thought you'd have to deal with. That's what Patricia Olivieri says happened to her after being harassed at work for years. She finally filed a complaint, but instead of getting help, she says HR turned against her and made things even worse. Today, we are breaking down what happened to Patricia, what her case means for the future of harassment claims, and how she fought against the odds to stand up for her rights and hold her employer accountable. And stick around until the end, guys, because this case has an interesting plot twist. Because Patricia's employer, they pulled out all the stops to try and block her from suing them in court. By the end of this video, you'll understand what Patricia Olivieri alleged happened to her, how her employer responded, what changed the game in her case, and for other harassment victims, and why this case sets an important precedent that could impact your rights if you ever face harassment at work. Hi, content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. On February 5th, 2018, Stifel, Nicolaus Company sent a letter to Patricia Olivieri offering her a position as a registered client sales associate in the Long Island, New York region. The offer letter gave the standard language, including Patricia's base pay, compensation, job title, and conditions, among other terms. But under the conditions section, there was important language indicating that, as with all Stifel employees, Patricia agreed to be subjected to all policies and practices of Stifel as set forth in the associate manual, any policy manuals, and other communications. Patricia Olivieri signed and returned the offer letter. Stifel, Nicolaus Company countersigned the offer letter. And on February 8th, 2018, Patricia also signed an associate handbook acknowledgement form. Let's pause for just a second. I want to say something really important to you here. One of the most important things you can do to stand up for yourself at work is to go back and review the documents you signed when you were first hired. I know a lot of people skip over that fine print, but those agreements, they hold critical details that can seriously affect your rights later on. If something goes wrong, like harassment or retaliation, those same documents you signed can come back to help you or even hurt you. That's why they matter. In this case, you'll see exactly how the paperwork that Patricia signed when she started her job ended up playing a huge role in her fight for justice. Stifel, Nicolaus Company is a major investment banking and financial services firm. They are headquartered in St. Louis. They provide wealth management, investment banking, and brokerage services to clients across the country. They have billions in assets under management, about $436 billion in client assets in 2021 when this case began. And they have thousands of employees and hundreds of offices across the United States. So we are talking about a major corporate powerhouse, not just a small business. And according to Patricia Olivieri, after she started working at Stifel, Nicolaus Company in February 2018, she says things quickly took a disturbing turn. According to her lawsuit, Neil Eisler, a senior vice president she reported to, would call her into his office frequently. During those closed-door meetings, instead of discussing work, he would talk to her about graphic sexual topics. He allegedly described his sex life with his wife in detail, told her stories about people he knew who had been raped, and did so with what she described as a big grin on his face. And he didn't stop there. Patricia said he also talked about cheating on his wife, having threesomes during lunch, and even told her about finding a used condom in his car. Then he would ask Patricia about her own sexual preferences. But it wasn't just words. Patricia alleged that Eisler sexually assaulted her and repeatedly harassed her. And so Patricia filed a complaint with Human Resources, but according to Patricia, instead of getting the support she needed to protect herself, the Stifel HR associate she worked with, Julie Gaffney, she actually took part in covering up what was happening. Patricia said that Julie advanced knowingly false excuses for Stifel's behavior. She ignored Patricia's protected complaints about the ongoing harassment and retaliation that Patricia said she experienced, and instead she tried to cover up the company's unlawful actions. Julie Gaffney also allegedly refused to address Patricia's concerns regarding disparate treatment with respect to Stifel's PTO policy and instead directed Patricia to seek clarification from one of Patricia's alleged harassers, Robert Codignato, while being aware that interactions with Robert Codignato caused severe distress and trauma to Patricia. Patricia Olivieri also alleged that Christina Skelta, one of Stifel's operations managers, assisted in Stifel's efforts to retaliatorily dock Olivieri's PTO in a more restrictive manner than Stifel had done with Patricia Olivieri's colleagues. Just give me a moment here. If you are a human resources professional watching or listening to this, be careful how you handle complaints. You can be personally, financially, and even criminally responsible for your actions. So always be mindful of what you're being asked to do. If you're ever told to do something that could put you at risk or hurt your integrity, that's your sign to change course immediately. Christina Skelta allegedly did this while also being aware that her docking of Patricia Olivieri's pay was a deviation from company practice, and did that to support and advance Stifel's hostile and retaliatory campaign against Patricia. Also, Christina Skelta allegedly participated in Stifel's efforts to exclude Patricia from meetings and ignored Patricia's emails, calls, and requests for work-related supplies. And it was these deeply personal and disturbing experiences that led Patricia to take her case to court. She filed suit against the company and its managers, both Neil Eisler and Robert Cognito, alleging gender discrimination, retaliation, and hostile work environment claims under Title VII of the Civil Rights Act of 1964 and the New York State Human Rights Law. Later, her second amended complaint, Patricia Oliveira added Julie Gaffney in Human Resources and Christina Skelta in Operations as defendants, stating their direct roles in retaliation, hostile work environment, and covering up harassment. In this case, it led to a landmark decision on the law called Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. So back in the day, forced arbitration agreements were the norm. If you were harassed at work and you had signed an arbitration clause, which almost everyone did, you had no choice. Your claim would be handled privately behind closed doors with no public record and very little accountability for the employer. But today things are different. In 2022, Congress passed a law called Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, also known as the EFAA. The EFAA is a federal law, and it gives employees the right to choose whether to take their sexual harassment or sexual assault claims to court. Even if they signed an arbitration agreement, it amends the Federal Arbitration Act to make sure that these claims can't be forced into private arbitration if the employee wants a public trial instead. So let's break down how this impacted Patricia Olivieri's case because it's central to understanding what happened and why this case matters. Patricia Olivieri filed her lawsuit in January 2021, before the EFAA was even passed. At that time, like many employees, she was bound by an arbitration agreement with her employer, Stifel. Then in March 2022, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, also known as the EFAA, it became effective. Here's the key. This is where it really matters. The EFAA isn't retroactive. That means it only applies to claims that came after or on March 3rd, 2022. So even though Stifel argued that Patricia should be forced into arbitration because her claims started before the law took effect, the court said no. And the court said no because the harassment continued after March 2022. And so, according to the court, the FAA applied. And this is so important because it means that employees can choose to have their claims heard publicly. Employers can be held accountable for unlawful behavior, and victims are no longer forced into private proceedings that often favor employers. The intent behind the EFAA is rooted in exactly what Patricia Olivieri went through. Her ability to sue publicly was what held her employer accountable. And now, thanks to the EFAA, that right is guaranteed for any employee asserting sexual harassment or sexual assault claims. If you want to learn more about arbitration agreements and how they affect your rights at work, be sure to check out my video called The Hidden Ways Employees Forfeit Their Right to Sue. Arbitration agreements are becoming really commonplace in workplaces today, so it's important to understand what you're signing. I'll link the video for you in the description below. Make sure you check it out. So now, thanks to the EFAA, that right to choose is guaranteed for any employee who is asserting sexual harassment or sexual assault claims. Have you ever heard that saying, birds of a feather flock together? That basically means that people with similar mindsets or behaviors, they tend to stick together. This is a company that asked employees upfront to sign arbitration agreements. Now, one way to look at that is a strategy to minimize financial risks for the organization. Lawsuits happen all of the time. But another way to look at it is that it's a way to conceal the complaints that run rampant, to avoid the payouts that might come if what's really happening in the workplace ever came to light. I also want to mention the bullying behavior Patricia said she experienced from Human Resources, the very department that is expected to uphold the law and to promote practices that protect employees from this kind of misconduct. Some organizations, they will seek out HR leaders who they know will play ball and look the other way. But it's a new day, and more HR leaders are being held financially and even criminally accountable for their failures and gross inadequacies. Despite all of this, remember, it's always better to protect yourself and stand up for your rights rather than accept discrimination. If you're experiencing harassment at work, know your rights. The EFAA gives you the power to choose court over arbitration for sexual harassment and sexual assault claims. And remember, there are other laws that protect you too. Check out my training on harassment and the harassment playlist, retaliation playlist, all on my channel. They will help you learn more about your options and how to protect yourself. As Patricia